Thank you very much. Just a few minutes to conclude. I think I am the last one to talk about last developments in Spain. Well, we don't have nothing special, but something very special, which is the new data protection regulation, which in addition to the European one, it's coming the national one. We don't know when. We have a political problem in the country now because the government coalition is divided and we don't know if any laws will be approved the next coming months. So we are living on the cloud and the clients are completely lost in the translation and in the application of the data protection. Which is very important, of course, for all the commercial and marketing activities. So we are trying to guide, following the opinions, but not still the guidance of the local authorities, the Data Protection Agency. From the point of view of the self-regulation, the authority, the auto-control, they have implemented the new mediation system in collaboration with the Data Protection Agency. Well, my expectations and in general expectations about mediation are not very high. It's not the first time that they try to do mediation and to impose it, but the mentality is not for mediation in Spain so far. So expectations are really low for the time being. From the point of view of good practices, the IAB in Spain, the branch in Spanish of IAB, they are still publishing very useful guides about the very actual and ongoing matters like the fake news and the ad blocking and also the influencers. Last year was the guide. And they are very useful in order to know the opinion of some neutral organization about how to interpret the application of the Spanish laws to these problems. And regarding the recent case law, very few weeks ago, we had a very relevant decision from the Spanish Supreme Court. It's a judgment about the interpretation of the principle of separation of advertising and information. It was usual during the football matches to put transparent ads on the television that were in the gray area of this was or not respecting the principle of separation and the principle of informing that this is advertising. And the final opinion of the Supreme Court has been that this is legal. So that they can continue under some conditions, of course, that they have to clearly identify and differentiate by acoustical or optical mechanism, but still it is allowable. From the point of view of the comparative advertising, we have had also a very important decision. We have in Spain a company called Pascual, it's a national company doing milk and food and orange juices, and they're very aggressive. They are always playing with the comparative advertising, and in this case they went against one of the main competitors, which is Granini. The case was because Granini was having a television advertising about the product where someone else was talking about nobody makes the juice like you. But in theory, the product of Granini was not juice, was nectar. This was on the label of the product. So the discussion was, it is enough for the consumer information that is on the label, or also the television advertising has to put this information clearly from the very beginning. The judgment was against Granini, and they were forced to change the advertising and also to make new advertising informing of the nectar quality, which is mixed with water. So it's for the court a very relevant information for the consumer and has to be revealed during the television advertising. And finally, also a very conflicting subject, which lasts about 10 years, about the copyright protection of commercial catalogs. This was a fight between two major local players having the Brico and products that you can make by yourself. They were copying each other, their catalogs. It was conflicting because during the first instance, the complaint was dismissed. It was about copyright infringement and unfair competition. The second instance in Sevilla, they said, no, no, this is copyright infringement and this is also unfair competition because it's nearly identical, the catalog. And then the Spanish Supreme Court took a very simple and direct way. There is no copyright, there is no originality on a commercial catalog, so you can copy it freely without any problem. So I don't know, you cannot say that this is applicable to all future cases about commercial catalogs, of course, but most of them seem the same. So it is a precedent to consider. This was all. Thank you very much for your attention.